Welcome to HOA Karen Expose. Like, comment your story, and subscribe for daily neighborhood drama. It was just another peaceful morning in a quiet suburban neighborhood. Lawns were perfectly trimmed, driveways spotless, and mailboxes stood in neat little rows. Everything looked like it came straight out of a real estate brochure. Except for one thing, or at least that's what she thought. Parked in front of one house was a sleek, fire-red sports car. Loud color, blacked-out rims, tinted windows. It wasn't just a car, it was a statement. And to most people, it looked awesome. But to Karen, head of the HOA and self-declared protector of community standards, it was an eyesore. The owner of the car? Just a quiet guy in his 30s who had recently moved into the neighborhood. He was polite, kept to himself, didn't throw parties, didn't blast music. But in Karen's eyes, he had already broken the unspoken rule, don't stand out. So what did Karen do? She started small. First, a note on the windshield. This car does not reflect the tone of our community. Please consider garaging it. The homeowner chuckled. He thought it was a joke. But the next day, there was another note. Then an email from the HOA board. Then an official letter, signed by Karen, stating that his vehicle violated the neighborhood's visual harmony policy. Visual harmony? Really? The letter demanded that he remove the car, repaint it in a neutral color, or face daily fines. It was absurd. The guy had checked the rules before he moved in. There was nothing about car colors. He wasn't breaking any laws or bylaws. His car was registered, insured, and legally parked on his own property. But Karen wasn't letting it go. She started showing up during the day to take photos. She told neighbors the car was hurting property values and making the street look like a racetrack. She even accused him of bringing down the reputation of the entire block. It didn't stop there. 1 week later, he got a letter saying the HOA was filing a lawsuit against him for violating community appearance standards. According to the complaint, the car's aggressive appearance caused emotional distress to residents and disrupted neighborhood unity. At that point, most people would have panicked. A lawsuit? Over a car? But here's the twist Karen didn't see coming. The guy she was trying to sue wasn't just any homeowner, he was a practicing attorney. Civil litigation, in fact. And what she had just done was walk straight into a legal trap. He didn't respond right away. While Karen bragged to the HOA board about putting that show-off in his place, the man quietly sat down at his desk, pulled up the HOA bylaws, and started reading. Every word. Every page. He wasn't angry. He was focused. This was his territory. It didn't take long to find the holes. There was nothing in the HOA rules about vehicle appearance. Not one clause about car color, design, or even custom paint jobs. Karen's entire complaint was built on vague, open-to-interpretation language like maintaining the visual character of the neighborhood. That wouldn't hold up in court. And he knew it. So he got to work. He drafted a formal response. Then, just for fun, he printed out a copy of the Freedom of Expression Clause from the state's homeowner law, highlighted in bright yellow, and attached it to the front of his response. Karen received the document 2 days later. And suddenly, the energy changed. She wasn't smug anymore. She called for an emergency HOA board meeting. But the damage was done. She had already filed the suit. It was moving forward. And now she was facing an experienced attorney who knew how to tear her argument apart, line by line. When the court date finally arrived, Karen walked in holding a binder of screenshots, photos, and community complaints, all written by herself, by the way. She claimed the car was disruptive, offensive to neighborhood sensibilities, and created an environment of discomfort. The judge raised an eyebrow. Then it was his turn. He walked to the front of the courtroom, calm, collected, with a stack of printed documents in hand. First, he submitted the HOA's bylaws into evidence. Then, page by page, he highlighted the complete lack of any rule about vehicle aesthetics. Next, he presented photos of other vehicles in the neighborhood, custom Jeeps, brightly painted motorcycles, even one neighbor's old delivery van with cartoon decals still stuck on the side. None of those vehicles had been targeted. Only his. Selective enforcement, he called it. Then came the final blow. He pointed out that, not only had Karen overstepped her authority, but she had also failed to consult the full board before initiating the lawsuit. According to the HOA's own governance rules, any legal action had to be approved by a majority vote. That never happened. The courtroom went quiet. Karen's face turned pale. The judge didn't even need time to deliberate. He ruled in the homeowner's favor, threw out the case, and ordered the HOA to pay his legal fees. The amount? Over $12,000. Karen tried to protest, but the judge shut it down fast. This was a misuse of power, plain and simple, he said. You don't get to bully someone because you don't like their car. By the next morning, the whole neighborhood knew what had happened. Karen, the queen of petty rules and HOA drama, had just been served a dose of reality, and a hefty legal bill to match. People were talking. Some laughed. Others were shocked. A few were just relieved that someone had finally stood up to her. The man. He didn't say much. He parked his red sports car in the same spot, polished it like nothing had ever happened, and went on with his day. Cool. Calm. Unbothered. But the mood in the neighborhood had definitely shifted. For years, Karen had operated unchecked. She'd cited people for flower pots, kids' bikes on lawns, even wind chimes. Wind chimes. Her favorite line was always, "It's not personal, it's about the rules." Except now it was obvious. She made up the rules as she went. And this time, she'd messed with the wrong neighbor. The HOA board scrambled. An emergency meeting was called, without Karen. Residents demanded answers. How did a lawsuit get filed without a board vote? Why were community fees being spent on legal nonsense? Why did Karen think she had the power to do that? She didn't. She was removed from her position that same week. An interim president was appointed. Someone fair, level-headed, and way less interested in micromanaging everyone's lawn decorations. The bylaws were reviewed, and guess what? A lot of them hadn't been updated in over a decade. That changed quickly. A new rule was passed that no legal action could be taken by the HOA without a full vote, documented approval, and transparency with residents. The guy who owned the car? He didn't gloat. He didn't rub it in anyone's face. But his quiet confidence said everything. He even attended one of the meetings, not to complain, but to offer to help revise the HOA policies. Legally and fairly. People clapped. Karen. She kept a low profile after that. No more notes. No more fines. Her influence was gone. And while she still lived in the neighborhood, she no longer ruled it. Residents started speaking up more. A few even made changes they'd been too scared to before. Painting doors bright colors, planting wildflowers, hanging flags. The place didn't fall apart. If anything, it felt more alive. And the red car? Still there. Still shiny. Still loud-looking. And still 100% allowed. What started as one person being unfairly targeted turned into something bigger. A reminder that rules only matter if they're fair, clear, and followed by everyone, including the people who think they're in charge.